Me.
Well, we've often seen, and some of us might have been those employees who kind of sent a medical certificate from your GP that just says, well, medical illness or something very vague like that. What legal standing does one have for refusing to disclose medical information when one, is required then to do so?
Okay, well, medical information is generally regarded as highly sensitive and personal information. It therefore enjoys extensive protection in South Africa and the rest of the world for that matter. Our common law prevents the public disclosure of private facts. There's also a common law duty on medical practitioners to preserve professional confidence. Now, that's much like the professional confidence between an attorney and his or her client, or between a priest and a parishioner. And then the National Health Act of 2003 actually takes it a step further and makes it an offence to disclose medical information without a patient's consent. There are 3 exceptions, though. These are quite important. I'll get to them shortly. I just want to mention as well that the HPCSA in South Africa, the healthcare regulator, has also brought out guidelines in respect of the disclosure of medical information. Now, getting back to those exceptions, there are 3 important exceptions when you are allowed to divulge or disclose medical information without a patient's consent. And the first one would be in a civil or criminal trial where a judge orders the disclosure of the information. We've seen this in the criminal case of our ex-president, Mr. Zuma, where Judge Pitkun has ordered the disclosure of his medical information. Then the second exception is legislation. So, by example, if you institute a claim against the Road Accident Fund, the fund would require you to disclose certain information, medical information that is, and you're obliged to disclose it, otherwise the Road Accident Fund could not entertain your claim or repudiate your claim. Now, the third one, and it's an important one in respect of employees, is the one of public interest. So this is where you weigh up the interests of the public versus the interest of the individual concerned. Now, in general, the medical information is, as I indicated, extremely sensitive and personal. So you would not need to disclose the nature of your treatment ordinarily. But for instance, if we look at something like your vaccination status, for example, you would expect that employers in due course would require their employees to disclose their vaccination status, because this is obviously in the public interest. And you could get a situation where, if you look, for example, a mine where 90% of the mine has been vaccinated and 10% of the workers are refusing to be vaccinated, in that case, the mine would be within their right, in terms of the public interest exception, to demand a disclosure of this information and ultimately either retrench or dismiss employees who refuse vaccination.
Let's talk about that. I think that's quite an interesting one, as we are indeed talking quite a lot about vaccinations. When it comes to the issue of public interest, that last one that you raised, when it comes to vaccinations, I mean, this will probably be something that goes to court in some case or other. At some point, someone will want to litigate when it comes to this sort of issue. I mean, what sort of precedent could those who are saying that, one has to disclose whether they've been vaccinated or not, what sort of precedents could those attorneys or lawyers have to then rely on in order to make the case for full disclosure of one's medical report?
You're 100% correct. I expect there to be many court cases on this point, and it will all depend on a facts-by-facts basis. So no matter will be the same. For instance, someone that's working from home and is not required to go to the office, it would hardly be in the public interest for such a person to disclose their vaccination status. So they would be well within their right not to disclose their vaccination status because it doesn't impact on workers at the work. But where someone is required to go into the work on a daily basis, employers could, in that case, insist on that. So it basically goes, there's no set precedent. Each case will deliver its own facts, and a judge would have to rule based on the facts of the specific case, whether it's in the public interest to disclose information or not.
Yeah, I just find this so interesting because, as I say, we're talking about the issue of vaccines, but when it comes to weighing up on the issue of agency of, my bodily integrity versus public interest, I'm to assume that any judge that's deciding on the matter would certainly weigh on the side of one having a bodily their own bodily integrity and deciding what goes into their own bodies. I mean, this is something that I think it's also enshrined in the Constitution in terms of what I can decide I want or what procedures I want on my own body. And I wonder if we had a case where it turned that public interest weighed higher, that we might be opening a can of worms in this regard when it comes to other medical procedures going forward. I mean, it is scary terrain if we're going to be talking about it in this way.
You're 100% correct. We must remember that there are certain rights that we're entitled to in terms of the Constitution of South Africa. The right to bodily integrity is one of them.
Yeah.
But we must also keep in mind that rights can be limited as well. So just the mere fact that you have a right doesn't mean it's an absolute right. It can be limited as well, and the limitation has regard to public interest. So every time there's any sort of limitation on a right, a judge would have to weigh up the public interest versus the interest of the individual concerned.
Yeah. What type of legal protection is available for people when they find themselves in such a position where they're being forced, of course, to give out their medical information? I mean, it goes back to what we're talking about in terms of bodily integrity, but what other legal protection could they then use?
Well, there's various options for them. Many employees or belong to a trade union, so many of the trade unions have legal representation. They could go to attorneys to assist them. So there's a lot of options. It all depends on whether they belong to a trade union, whether they don't belong to a trade union. But most attorneys would be able to assist with advice. And as I indicated, I mean, it's on a facts by facts basis. So no case will be the same. They would have to approach an attorney and disclose the particular circumstances of their employment, and the attorney would advise them accordingly.
All right, Mr. Rudd, a great pleasure speaking to you. Thank you for giving us your time, and I hope we can certainly have more of these conversations on the show. Thank you, sir.
Thanks for having me.
You're most welcome. All right, that is civil litigation attorney Jean-Paul Rudd talking to us about a disclosure of your medical report and the exceptions, when you should, when you can, and it's certainly something that we should be discussing as we go on.